Good day, students, and welcome to today's session where we will be discussing limited real rights. Please take note that this is merely a brief overview of the specific units. You are still required to study the entire content of your study guide in your own time. On the diagram, you can see that there are three categories of limited real rights, namely servitudes, restrictive conditions, and real security rights. But before we look into these three categories of servitudes, let us focus on the definition of a limited real right and how it differs from ownership. Limited real rights are real rights which a person has over another person's thing, whereas ownership is a real right with regard to one's own thing. What is a servitude? A servitude can be defined as a limited real right to another person's thing. It confers specific entitlements of use and enjoyment on the servitude holder. There are two categories of servitudes, namely predial servitudes and personal servitudes. Predial servitudes is a limited real right in the land of someone else, which grants the holder of the servitude certain entitlements of use and enjoyment in his capacity as owner of the dominant tenement. Land servitudes are created in favor of a piece of land. In other words, one land, the servient tenement, serves the other land, the dominant tenement. An example of a predial servitude would be the right of the owner of the dominant tenement to drive, walk, herd, cattle, and transport products over the servient tenement. An example of a predial servitude in this situation would be where S, who is the owner of Highlands Farm, has a servitude of right-of-way over Pulang, which belongs to Q and R, in order to access X and Y's farm on Waterfall. So the land over which the servitude of right-of-way is registered is the servient tenement. So Pulang would be the servient tenement, and Highlands will be the dominant tenement. Personal servitudes. A personal servitude is different from a predial servitude. A personal servitude is a limited real right to the movable or immovable property of someone else, which grants entitlements in respect of the thing to the servitude holder in his personal capacity. There are three categories of personal servitudes, namely a usufruct, use, and habitation. A usufruct is the right to use and enjoy the property belonging to another, as well as the fruits thereof, with a duty to return the thing to the owner with the preservation of its substance. For example, in the case of a usufruct on a farm with a certain number of trees and cattle on it, the farm must be restored to the owner with the same number of trees and cattle, not necessarily the same trees and cattle. A personal servitude of use is the right to use and enjoy the property of another for his or her own needs, and those of his or her household, provided the character of the thing is preserved. This servitude is more restricted than a usufruct in that it entitles the holder to use the property, but not to draw its fruits. And a personal servitude of habitation is the right to occupy a house. Now, an example of a personal servitude of habitatio would be M residing on X and Y's farm. Now, M has a right of habitatio, which means that she has a right to occupy that house for as long as she lives. What are the differences between land and personal servitudes? A land servitude is created in favor of a piece of land, while personal servitudes benefit someone in his or her own personal capacity. As you can see, M, the servitude of habitatio, benefits her in her personal capacity. In the case of S having a servitude of right of way over Pulang to access the farm of X and Y, namely Waterfall, you can see that the servi-in tenement serves the dominant tenement. And that is how personal servitudes differ from pradial servitudes. Another way in which pradial servitudes and personal servitudes differ from one another is that pradial servitudes last indefinitely. In other words, should S sell his farm to a new owner, that owner will also be entitled to a servitude of right of way over Pulang in order to access X and Y's farm. Whereas in the case of a personal servitude, it is granted for a specific period or for the holder's lifetime, or if not granted for a specific period, in the case of legal persons, for 100 years. Land servitudes can be established over immovable things only, and personal servitudes may be established over movables and immovable things. Furthermore, land servitudes are alienated together with the land, whereas personal servitudes are inseparably attached to the holder's person and are in no ways transferable. For the requirements for the validity of a land servitude, please see your study guide. A public servitude. Public servitudes are established for the benefit of the general public, for example, the right of outspan and commonage. This is not a land servitude as there is no dominant tenement, nor is it a personal servitude since the right is not vested in a particular person. Examples of a public servitude would be a right to use a road, outspan, to cut wood for own use, or the right to picnic in certain spots. Restrictive conditions are also limited real rights, and its restrictions on the use of land and are usually registered against the title deed. Restrictive conditions can be described as limited real rights that operate under specific circumstances, namely in the planning and management of land use, often to preserve the character of the neighbor. For example, no house in a certain township may be smaller than 250 square meters, and no corrugated iron roofs are allowed. Or it could state that if you purchase a house within a security complex, that you are not allowed to change the color of your house, in that all the houses in the security complex should have the same color. Now let's move on to the second category of limited real rights, namely real security rights. What is a real security right? A real security right is a limited real right over another person's thing. To ensure that the debtor pays a principal debt, the creditor can require that the debtor provides security in respect of the performance to the creditor. If the principal debtor does not fulfill the obligation, the creditor can use the security object to satisfy the debt. For example, A and B is in a motor vehicle accident. B was negligent. B agrees to pay compensation for the damage to the motor vehicle. As security for the payment of damages, B pledges his motorcycle to A. A acquires a limited real right over B's motorcycle. Personal security rights are not limited real rights. Now, personal security occurs where a person, the surety, bind him or herself personally to the creditor for the performance of the debtor's obligation. Example, A sells his car to B. C, B's father, stands as surety in terms of which C undertakes to pay the amount due to A should B fail to pay the amount to A. Take note that the creditor obtains only a personal right and not a limited real right against the surety. And furthermore, take note that the law of property is concerned only with real security rights, while the principles of suretyship are dealt with in the law of obligations, specifically the law of contract. Conventional and tacit real security rights. Real security rights are divided into conventional security rights, which are based on agreement between the creditor and the debtor, and tacit mortgages, which arises by operation of the law. The purpose of real security rights is aimed at strengthening the creditor's position, especially in the case of a concurrence of creditors, in the case of a debtor's insolvency. Where several creditors have claims to the same estate on insolvency, the principles of equality of creditors applies. According to this principle, all creditors are on an equal footing as holders of claims, and none is entitled to preference. To avoid this unsatisfactory position, a creditor may secure his or her claim for payment by means of a real security right, which will give him or her a preferential claim to the proceeds of the object of security. It is only when his or her claims has been satisfied can the other unsecured creditors lay claim to the free residue. The three legal acts involved in creation of a real security right are as follows. There should be a loan contract in terms of which the creditor lends a sum of money to the debtor. The debt created here is the principal debt. The security contract in terms of which the debtor undertakes to provide security for the debt created in terms of the loan agreement. Thirdly, there should be vesting of the limited real right. Vesting takes place where there has been delivery of the thing to the creditor. So it's important to note that all real security rights are accessory in nature. This means that the security rights cannot exist if there is no principal debt. When the principal debt is discharged, the security right is extinguished by operation of law. Now, an example of a conventional real security right is a pledge. A pledge can be defined as a limited real right over the pledge's thing, delivered to the pledgee as security for repayment of the principal debt, which the pledger or a third person owes to the pledgee. To constitute a pledge, there should be a principal debt, a pledge agreement, and delivery. If there is only a principal debt and a pledge agreement, only a personal right will be established. Whereas if there is a principal debt, a pledge agreement, and delivery, real security rights will be established. For example, Daniel has lent Luke some money and has taken Luke's flat screen TV as a form of security. Please see your study guide for clauses in a pledge agreement and the rights and duties of the pledgee and pledger. A mortgage. A mortgage is a limited real right over a thing belonging to a mortgager in order to secure repayment of a debt owed by the mortgager or a third person to the mortgagee. Mortgages can be divided into two groups, namely conventional or expressed by means of an agreement and tacit mortgages created by law. Express mortgage is established by an agreement and registration. Both movable and immovable things may be burdened by a mortgage. An example of an express conventional mortgage is a notarial bond. It is a bond registered over the movable property of the mortgager. There are two forms of notarial bonds, namely general notarial bonds and special notarial bonds. General notarial bonds are applicable to all movable property of the mortgager, whereas special notarial bonds are applicable to specifically described movable property of the mortgager. General notarial bonds are applicable to corporeal and incorporeal movable property, whereas a special notarial bond is only applicable to corporeal movable property. Now, with regard to a security object, a general notarial bond hypothecates all the movable property of the mortgager in general. This includes corporeal and incorporeal movable property, whereas in the case of a special notarial bond, hypothecates specifically described movable property of the mortgager. This movable property is limited to corporeal movable property. A real right security right in the case of a general notarial bond based on perfection of the bond by means of attachment, whereas in the case of a special notarial bond, in terms of the security by means of movable property act, a real security right vests in favor of the mortgagee upon registration of the bond. In the case of a general notarial bond, the notarial bondholder is an unsecured creditor but enjoys preference in respect of free residue over concurrent creditors of the debtor. After perfection, the notarial bondholder is in the same position as the pledgee and therefore a secured creditor. In the case of a special notarial bond, the notarial bondholder has a real security right and therefore a secured claim against the insolvent estate. A special mortgage can be established only with regard to a particular immovable thing and cannot be established over immovables in general. The mortgagee acquires a limited real right over the mortgaged land. Although the mortgagee is not in control of the mortgaged land, the mortgager cannot establish any other real right over the mortgaged land without the mortgagee's consent. The mortgager retains control of the mortgaged land. It is possible for him or her to constitute more than one mortgage over it, and the first registered mortgagee enjoys preference over subsequent mortgagees. For the categories of special mortgages over immovable things, please see your study guide. Security by means of claims can be granted in one of three ways: a pledge of claims, a fiduciary security cession, or by means of a notarial bond of claims. Security by means of claims is therefore providing security by means of an incorporeal thing. The type of incorporeal thing that can be provided as security are personal rights that you have that are assets in your estate. For example, your personal rights to your salary or your claim against your insurance company is an asset in your estate, and such assets can be sold and transferred by means of cession. In the same way that I can deliver my car in pledge to my creditor to secure payment of the principal debt, I can cede my personal right to payment of my salary against my employer to my creditor in pledge. Cession can be defined as an act of transfer in terms of which a creditor transfers his or her personal right against his or her debtor to the cessionary in such a way that the cessionary steps into the shoes of the cedent as creditor. This transfer takes place by means of a transfer agreement. We have now discussed conventional mortgages. In this section, we will discuss tacit mortgages. Now, tacit mortgages consist of the tacit hypothec, liens, and judicial pledge. So let's move on to the first category of a tacit hypothec, namely the landlord-lessor hypothec. This hypothec secures the landlord's claim for rent in arrears and is created by law as soon as the lessee is in arrears with rent payments. What happens when the property on the premises belongs to a third party and not the tenant? When goods belonging to a third person are brought onto the leased premises with the knowledge and consent express or implied of the owner of the goods, and with the intention that they shall remain there indefinitely for the use of the tenant, and the owner being in a position to give notice of his ownership to the landlord fails to do so, and the landlord is unaware that the goods do not belong to the tenant, the owner will therefore be taken to have consented to the goods being subject to the landlord's tacit hypothec and liable to attachment. The four requirements set out by the court are: the property must be in the landlord's premises with the knowledge of the actual owner. Secondly, there must be a degree of permanence regarding the property on the premises, which should not merely be temporarily stored there. The property must be on the premises for the use and enjoyment of the lessee. And fourthly, the landlord must not be aware of the fact that the property does not belong to the lessee. The credit grantor tacit mortgage or hypothec. This is in terms of a credit agreement in which the seller retains ownership of the property until the last installment has been paid. It secures the credit grantor's claim for outstanding payments in terms of the credit agreement in cases where the credit receiver becomes insolvent before payment of the last installment. It is a form of security for the credit grantor that the credit grantee will discharge the debt. The ownership of the credit grantor changes to a limited real right in the event of the credit grantee's insolvency. The effect of this section is that the credit grantor loses his or her ownership on insolvency and acquires a tacit hypothec against the insolvent estate. Another category of a tacit hypothec are liens. Liens is a limited real right to secure the claim of a person who has spent money or done work on another person's thing. It entitles the lien holder to keep the thing until he or she has been paid. For example, a car might be repaired by a workshop for you. The workshop may withhold the car from you unless you pay them. There are two categories of liens, namely the debtor and creditor lien and enrichment liens. In the case of a debtor-creditor lien, the principal debt arises from an agreement. It is enforceable only against the other contract party and is regarded as a personal right. When the principal debt arises from enrichment, the lien is classified as an enrichment lien. An enrichment lien is enforceable against third parties and is regarded as a limited real right. The third category of tacit hypothecs are the judicial pledge. A judicial pledge. A creditor can obtain real security in the form of a judicial pledge by way of attachment in terms of a writ of execution. Upon attachment, the creditor acquires a real security right similar to a pledge over movables or a mortgage over immovable property. In terms of the writ of execution and upon attachment, the creditor can have the property sold on execution by the sheriff, and the creditor's claim enjoys preference. Real security rights established before the attachment will enjoy preference on the basis of their being created earlier. Thank you for your attention, and this concludes today's session.